This is a part-heard appeal in the matter of HMRC and Boat Services UK Ltd.
Yes, slide.
My lords, my lady, there is a bundle which I hope I will mainly not need to go to. It's got a few bits, some of it which is corrected printings from the bundle, and a couple of things which were omitted, even though they're mentioned in the skeleton and one passenger notice. I'll come to that if I need to in the course of my submissions. So we were in the case law, and I'm going to resume the case, unless, of course, the court has any questions for me before I begin. So could we please go to Star Coaches, which is in the authorities bundle at 231. So there's no Advocate General opinion on this, it's a reasoned order. And we can see in paragraph 8 what it concerned. It was Star Coaches was engaged in the transport of persons by coach. It operates the transport either with its own coaches, that obviously be in-house, or by using subcontractors. And its customers are exclusively travel agents established in the Czech Republic or in other member states. And it deals with its customers in its own name. Paragraph 13, the question was raised that whether its supplies fell within Article 306. Must it be classified as a travel agent within the meaning of that provision? And the National Court indicated in its view that's not the case, where the undertaking provides only a transport service and no other tourist services. It follows that the present case must be distinguished from Van Ginkel, in which the undertaking concerned, in addition to accommodation, also supplied information, advice and reservation services. And if we come to the reasoning of the court, we can see, picking this up at paragraph 21, we can see that regardless of the formal classification of economic operator, the underlying reasons for the special scheme are valid where the operator is not a travel agent or tour operator in the normal sense of the words, but in the context of another activity affects transactions identical to theirs, and refers to Matchett and Baldwin. 22, it cannot therefore be ruled out that the services of an operator of passenger transport by coach, who when not using his own coaches has recourse to the transport services subcontractors liable to VAT, may be subject to the special scheme. The circumstance that those services do not include accommodation services cannot suffice for them to be excluded. Then it goes on to 23 in Van Ginkel. However, following the approach adopted by the court in Van Ginkel, it is also necessary that those services cannot be reduced to a single service, and that they comprise, apart from the transport, other services such as information and advice. Now, we'll come on to see that that's an incorrect interpretation of Van Ginkel, and this needs to be read in the light of Alpin Chalets. The court has held that it cannot be inferred from Van Ginkel that any individual service falls within the special scheme laid down in Article 26 of the 6th Directive, and then refers to Minerva. But of course, Minerva referred to operatives not being a travel service. And so 24, in the case of Star Coaches, the referring court states that it provides only a transport service for travel agents and no other service. And the court expressly adds the company does not provide any service such as accommodation, tour guiding or advice. It follows that the services supplied by Star Coaches are not identical to those offered by a travel agent or tour operator. So one might infer from that, although one has to read it in light of the later case law, that a passenger transport service can be identical where it is accompanied by advice or information. And we'll see there is no delving into details about what that advice or information could or must comprise. You'll note that the reference to Van Ginkel was simply here, it was advice in relation to the bookings.
Sorry, where does it say that?
It was 20, it says, such as an information advice by means of which the travel agent provides a range of holiday offers and the reservation of accommodation. Now, the next case was commissioned in Spain. As my learned friend said, that's after Star Coaches, and pointed out that wholesale supplies B2B are within TOPS. There's also, I'm just going to go briefly to the Advocate General, because there's a passage that was picked up by the tribunals below, and that's on the concept of travel. That's at page 251, paragraph 42. Could I just ask the court to read that to yourself?
Did you say 42?
Paragraph 42 on page 251.
That's my fault. Thank you.
This is the Advocate General, isn't it?
Exactly, yes. So we saw in IST the court declining to set out the factors which constitute travel. And here we have the Advocate General similarly recognising that travel can be very broad. There's no restrictive definition of it. Then please could we go to Alpen Chalets at 336.
Well, you've just taken us to a paragraph in the Advocate General's opinion in Commission Spain, but is there nothing in the judgment?
The judgment doesn't define travel, doesn't go into travel, but does follow the broader concept of traveller to include customer, any sort of customer.
All right.
Now we're going to go to the Advocate General in Alpen Chalets. Now I'm taking on board that the court does want to focus on the European Court's judgments, but in my submission it is important to read Alpen Chalets and the Advocate General, because this is where the Advocate General, Bobeck, goes into some detail in looking at what's happened to the TOM scheme and trying to make sense of it, make it coherent. And we can see how he analyses it is then consistent with the subsequent developments in the case law. And we know that the cases can be quite Delphic. They can be short, they can be sometimes quite difficult to understand. And here we have the benefit of Advocate General Bobeck. Now, I'm not saying that the court adopted all of this analysis. I'm not putting it forward as that, but I am saying that it does shed light, and it's a useful analysis of what's happened in the case law and how he understands it conceptually. Now, this case concerned, if we can see in paragraph 1, Alpen Chalets which rented houses from their owners and then let them for holiday purposes to its customers. And on arrival, the owners or their agents provided further services such as cleaning and in some cases a laundry and bread roll service. And the question you could see was, does that qualify as a service provided by a travel agent? Now, pausing there, it could easily have been argued that was, and indeed that's what Alpen Chalets did argue, that this was a holiday let sector. This was in the holiday let sector, not the travel agency sector. And if we just go back to page 12 of the authorities bundle, I think we went to this yesterday, but you'll recall that one of the sectors which benefits from a reduced rate under the Principal VAT Directive, if one looks at 12 of Annex 3, is accommodation provided in hotels and similar establishments.
Sorry, may benefit from the reduced rate.
Yes, yeah. But we've seen, so one of those at 5 is transport of passengers, and HMRC rely on that to say this is different. The TOM scheme applies to travel agents. There's a different regime for transport of passengers. They can lose their reduced rate. But if you look at 12, we can see there is the accommodation provided in hotels and similar establishments, including the provision of holiday accommodation and the letting of places on camping or caravan sites. So one might have thought that what Alpen Chalets was doing was firmly in the holiday let sector. And this is my point, you'll recall I made it yesterday. It's wrong to look at this as sector versus sector, such as minicab sector versus travel agent sector. The same way that it's wrong to say holiday let sector versus travel agency sector.
So, just trying to think through what that means, because obviously this a hotel provided in-house, if you like.
Yep.
Which is what Manchester and Baldwin
Yes.
was doing, would have benefited from, if it applied in the UK, a reduced, or could have benefited from a reduced rate.
Yep.
Under this provision. And that's still
That remains the case.
that remains the case.
It's just whether you buy in and resupply. And that's why open chalets is important. The only difference is it's buying in and resupplying. We'll come on to see this. It's buying in and resupplying. It's not doing anything more. There's no suggestion that it's offering transport, offering advice, offering a range of holidays. It's buying in and resupplying accommodation.
What I'm trying to think through is that the points about distortion potentially arise there then, don't they? So contrast bought-in accommodation, holiday accommodation with holiday accommodation provided in-house.
Well, it's a different model. So remember, if they're buying in, all that the Alpen Chalets would be accounting for is on its margin. It's additional. What it's doing in addition to the core.
So the distortion is actually not, maybe not that great.
Distortion between what?
Between the in-house, I mean, I'm just focusing on the contrast between an in-house supply of accommodation and bought in, because one of the points being made against you is around distortion of competition sector by sector. So I'm just focusing on that.
No, we say there's no distortion of competition. It's inherent in the scheme that if you are buying in and resupplying, it's different from you supplying from your own resources. We see that in all of these cases.
If Tom's applied in, let's say there was a supply of accommodation to a travel agent in a jurisdiction where a reduced rate applied, that reduced rate would still apply.
Exactly, you don't lose
on
it.
the supply to the travel agent.
Exactly.
So actually that is not
Exactly.
particularly distortive.
Yep.
It's being, okay.
Yeah.
I think
And having said, and just to make good my point that, and I made this in opening, if we go to paragraph 2 of the VAT treatment of passenger transport in the UK, I just want to address this point now.
Where are you
So
looking?
this is this additional bundle, tab 2.
Is this something we've got in?
No, this is a different VAT notice.
No, I think I'm just preferring to work off soft copy.
I'm afraid we don't have it. This is the only
I think
copy.
we do.
Oh.
I've got it. What are we looking at?
It's the VAT treatment of passenger transport, VAT
Yes.
notice 744A.
Yes, page.
Sorry, what's this
49.
got to do with Alpen Chalet?
Because I'm just addressing my lady's question or point about what happens when you get a reduced rate, and is it distortive or is there a problem when it's then resupplied? And I'm going to make one short point on this notice in relation to that. And because we're addressing that particular theme of the case, I thought it would make, rather than coming back to this later, it's more efficient for me to deal with it now.
Page.
It's not in the it's not in the electronic bundle, I don't believe. It's behind tab 2 of this.
I know, but I've got.
Oh, sorry,
this bundle
49.
electronically.
49.
Thank you.
So you can see this is about the VAT treatment of passenger services.
Yes.
And if one looks over the page at 1.2, what passenger transport services are, you can see it's supplied when a vehicle, ship or aircraft is provided together with a driver or crew for the carriage of passengers. And then if we go to section 4, which is on page 55, we see the reduced and zero rate passenger transport, and there are various types, including, for example, 4.7, transport in taxis, limousines and hire cars, which is standard rate unless the vehicle has 10 or more seats. And then if you look at 4.10, if you're an agent who buys in passenger transport and resells its principal, you use TOMS. That's 4.10 at the bottom of 57. So It's as simple as that.
Okay.
It's not new
No,
or...
I understand.
Yeah.
You've answered my question.
Thank you. So if we go back to Alpen Chalets,
Yes.
so we're on page 336. So we've seen what it does is buy in and resupply. And if we then jump to the body of the Advocate General's analysis, we can see page 340, he starts with who is a travel agent. And that's paragraphs 21 to 25. And then he makes the point in paragraph 25, whether the second condition applies, i.e. using third-party supplies, whether the second condition is satisfied is less clear due to uncertainty as to whether the existence of one bought-in service is enough or whether there must be at least two supplies. If the latter option were contemplated, the issue immediately arises as to what kind of supplies they should be. And it's to those issues that he then turns. And he then comments on Van Ginkel and Star Coaches. This is on page 341. And can I ask the court to read to yourselves paragraphs 27 to 30, where he analyses Van Ginkel and Star Coaches. So then over the page, and please stop me if I'm going too fast, but over the page, he then notes that the approach to Star Coaches seems to better reflect the wording of the directive, which envisages multiplicity of services of all goods. He notes in paragraph 32 that requirement of multiplicity echoed in several legislative documents. He looks at 33, the objectives suggest that simplification sought was tailored to accommodate substantive and geographical multiplicity of services. And 34, at the level of principle, the court keeps recalling that idea of multiplicity. And paragraph 35, he goes, however, beyond the level of those general propositions, it's fair to admit that the content of the exact test is not easy to discern. In particular, in the view of the Van Ginkel Star Coaches tension, is one service enough? Which one? If multiplicity of services is required, which combinations will qualify? Only accommodation and transport, accommodation and something else, transport and something else? As correctly noted at the hearing, a potential analogy with the directive on package travel, which could provide at least some guidance and definitions, appears to have already ruled out by the court, and that was the IST case. There's then a fairly lengthy section looking at principal and ancillary, which I'm not going to go into. And if we have a look at paragraph 46, we can see there was a suggestion in that case that Alpen Chalets provided information and advice. 46 is on page 345. Furthermore, it suggested that the applicant provided information and advice to the customers by making information available on the applicant's website. That was the content of the information and advice. At the hearing, the respective parties have disagreed as to the implications of this suggestion, namely whether the provision of information and advice was necessary for the supply as a whole to fall under the special scheme for travel agents. So that's the sort of information and advice that was in that case. If we then jump over the page, you can see it's a lengthy analysis, and I'm not going to go through all of it, obviously, but on page 346, we can see at the top paragraph 50, he says the case law suggests the multiplicity of bought-in services has not actually been required by the court as a condition for the special scheme for travel agents to apply. And 52, at this stage, there is no disguising that if the latest pronouncement of the court made in Star Coaches requiring the establishment of multiplicity of services were taken its full value, the level of complexity in deciding what constitutes a service provided by a travel agent falling under the special scheme would be considerable, to say the least, with the exception of the rather clear situation of a travel agent combining bought-in accommodation with bought-in transport. Furthermore, the elements of definition of the required composition of services, as well as their exact relation and their exact mixture, would need to be made clear. So then he comes on to, is one bought-in service still enough? And could I ask the tribunal to read that section, which is section 3 of his advice. That's paragraph 53 onwards. He then carries on looking at the arguments which support the one bought-in service is enough. One can see that at the bottom of 347, 61, where he refers to weighty arguments as to why one bought-in service, provided that it relates to either accommodation or transport. Those are the two key elements of the travel services should suffice. Then he looks at 62, judicial practice. 63, he looks at the level of the scheme and the risk of it becoming excessively narrow. And then in 64, he says the counter-argument is over-inclusion. As he says at the bottom of paragraph 64, traders that provide only one travel-related service, such as the applicant, will fall under that regime. He says that might be said to be normative overreach, but he says then that is for the legislation to deal with by amendment. As he says, all in all, it's perhaps, this is 65, it's perhaps fair to admit that despite the heralded objective of simplification, the implementation of that ideal in the specific context of the special scheme for travel agents remains rather remote from that state ideal. That particular scheme has become one of the most complex areas of VAT. And so he says the first question should be answered as the provision of one bought-in service is enough, provided that bought-in service is accommodation or transport. Then let's go to what the court said, and that's at 355. Now, it's important to have a look at the wording of 18.2, the question being referred. 18.1. Is the supply of a service which consists essentially in the provision of hotel accommodation and which additional service components are to be regarded merely as ancillary, subject to the special scheme under Article 306. So this is the provision of holiday accommodation, and it's just that. And there's no reference to Alpen Chalets being a travel agent in the ordinary meaning of the word. It doesn't offer a multiplicity of services. Then at the bottom of 355, the court refers to Van Ginkel and affirms the Advocate General's view that Van Ginkel says the mere supply of accommodation by a travel agent can be covered by the special scheme, and then gives the concept of a travel agent. Travel agents offer widely different types of holidays and journeys, allowing the traveller to combine as he wishes transport, accommodation and any other services. Now, of course, Alpen Chalets doesn't do that. And then the court goes through saying in the My Travel case, this is all confirmed, it refers to My Travel. And then 28, it follows from paragraph 29 of the judgment IST that the special scheme for travel agents applies to a trader who offers to its customers in return for a package price, in addition to services associated with language training and education, supplies brought in from other persons, such as travel to the host state and or the stay in that state. The term and or demonstrates that one of those services can in itself be sufficient for that special scheme to apply. And I ask you to note the level of generality. It's travel to the host state and or the stay in that state, not descending into the detail of it being several months in an educational establishment. And then 29, Minerva picks up the point that it's not that any service whatsoever supplied by a travel agent falls under the special scheme. But they have been, the supply by a travel agent of a holiday accommodation comes within the scope, even if that service covers accommodation only transport. And then paragraphs 30 to 32, it confines star coaches to its particular factual scenario. 32, this court merely noted that the transport services cannot be covered by Article 306, whether provided through a subcontract, not to the traveller himself, but to travel agents, and that transport operator does not have any other feature which is capable of making its services comparable to those of a travel agent or tour operator. Now, in my submission, what's doing there is confining star coaches, because actually that rationale doesn't make sense, because we know from Commission in Spain that a B2B service falls within TOMS, and the only feature that was considered in star coaches as missing was advice and information. But there's no suggestion, no reliance here that Alpen Chalets provides any advice and information.
Sorry, when you say how are they explaining star? Are you saying they're actually saying it's wrongly decided?
My lady, if you're going to press me, I'm
they
going to say
can
yes.
do that, and they have done that.
Well, my lady, as we all know, it's exceptionally rare for the European
But they
Court
have done
to
it.
ever say. I mean, the reality is, in most cases, they try very hard not to do that. And I mean, my learned friend herself said yesterday star coaches was wrongly decided. We agree with that.
Sorry, you do?
We agree that star coaches, in saying that you had to provide information or advice, was wrongly decided, because that's a misreading of Van Ginkel, as the Advocate General said.
I didn't say that.
I didn't understand you two. I'm trying. Can we just make sure we understand your position?
Yes. My position is exactly what the Advocate General said, which is that star coaches misread Van Ginkel.
So do you say that that means that star coaches was simply wrong?
Yes. And needs to be read in light of the subsequent case law, which makes it clear that information and advice is not required. Alpen Chalets being one of those cases, and we'll come on to see the case of C. Now
So you've still got to address what's actually said in paragraph 32.
yes,
Not.
I will, and I'll come on to that,
Yeah.
because I'm saying you've got to read this in light of the subsequent cases. And I would also point out, you'll recall that the FTT found that the single transport service was enough, but if he was wrong on that, if the panel was wrong on that, the first tier, they found that Bolt does supply advice and information. So we say it both ways. We say we don't accept, when you read all the case altogether, that it's a necessary condition.
So I think you're going to have to go a bit more slowly, because this may be important.
Yes.
You say star coaches is wrong.
We say star coaches was wrong insofar as it said that the single supply of passenger transport on its own is not enough. You need another feature, that feature being information and advice. But in any event, this is what the FTT found, if that feature is required, it is satisfied in this case.
Can I ask a slightly different question,
Yes, my lord.
but related? Is it your submission that paragraph 32 of Alpen Chalet is wrong?
No, I think it's carefully worded. It says the court merely noted. The court did note.
So let me then ask a follow-up question. Do you accept that it's correct?
That the court noted in that case. Yes, the court noted in star coaches.
But is it based on a correct appreciation of the law?
My answer to that, my lord, is my primary answer is no. But my second answer is if I'm wrong on that, then we say it is satisfied. But I do want to come on to the rest of the case law, because the case of C is relevant to this as well.
Well, can we?
Yes.
Can we just please look again at the last line and a half and
Yeah.
you tell us what your position is in relation to that? The reason given in that last line and a half.
So they
What was
say,
described yesterday as part B.
well, let's be careful here though, my lady, because it's not fair for HMRC to say, well, we can accept that part of it's wrong, but some of it's, we're not allowed to say that anything else is wrong. Let's bear in mind.
No,
my
there's
understanding
no,
is-
well, let's be clear, I don't think there's any suggestion that Appellant was wrong.
No, I don't think there's any. But my understanding is it's common ground that the fact that the services of provider are provided B2B, not to the traveller but to travel agents, is not a good reason for it to fall outside.
No, that's part A.
Exactly.
The division, I'm focusing on part B.
Yes, but just to make it clear, my lady, the point I'm making is my understanding, here this implies that both parties agree that insofar as the style coaches, and that's being repeated here, is that is a rationale for being outside the scope of the scheme. That's wrong. Part A.
I'm not asking about part A. Let's take that as a given.
Fine. And so part B, yes, for the same reason, because the does not have any other feature which is capable of making its services comparable. It's the, if we remember, we went to that, but the reason for that was its misreading of Van Ginkel. The reason it says you need something more was Van Ginkel. Do you want to go back to Star Coaches and have a look at that?
No,
because
we're
we're not
quite clear.
interested in star coaches, we're interested in what the court has said in Alpechat.
But in Alpen Chalet, the court has repeated both things, and I say that both things are wrong.
Okay, can I ask you this question? Let's try and get to the basics. Is there any reference in paragraph 32 to advice and information?
No.
Right. So, therefore, what is wrong with the proposition? What matters is whether the services are comparable to those of a travel agent or tour operator, because that seems to be what the court is saying.
So, my lord, my submission is that if your services are comparable to those of a travel agent, if the services themselves, such as accommodation or resupply of passenger transport, are being resupplied. You don't need more than that, because I ask rhetorically, what is the any other feature? What is the any other feature? Where do you get that from the case law? And where do you get that in Alpen Chalets itself? In Alpen Chalets, it's resupplying accommodation.
So that seems to be a submission that no other feature is required.
Yes.
So you read that as saying, actually Star Coaches was, all it's saying is Star Coaches was wrong in this
I do,
phase.
my lady,
That's,
Exactly.
you read that as European, I mean, yes, they can be Delphic, but that is quite Delphic, isn't it?
Yeah. I do. Because otherwise, where in the case law, what is the feature? One doesn't see that reference in other cases to any other feature. And Star Coaches, the only feature they refer to is information and advice.
Well, but you do see several references to identical or comparable.
Yes, at the level of the services. Are the services comparable? And we've seen, this is why I went through the Advocate General. That's why conceptually it makes much more sense to say, are the services, what are the services, transport or accommodation being resupplied? And let's just test that by looking at Alpen Chalets. What is the other feature that Alpen Chalets had?
Might a distinction be drawn, do you think? I know you say not by the Advocate General. Might any distinction be drawn between accommodation and transport?
So, my lady, not that the court has drawn.
Not that the...
Not that the court has drawn. In my submission, it's difficult to see any rationale why the mere supply of reaccommodation without any advice or information is within tolerance, whereas in order for the resupply of passenger transformation, you'd have to have advice or information as an additional feature. One doesn't get that from the case law. But even if that were the distinction, that condition is met in this case.
Even putting to one side the question of information or advice, might there be any qualitative distinction between accommodation and different types of transport?
On the case law, it's not drawn, my lady. On the case law, it's not drawn.
Yes, although, I mean, you have spent time on the Advocate General opinion, you've taken us to the judgment, and when it refers to the and/or travel or accommodation, it's actually talking about travel to the host state for what that's worth. And we haven't got to the most recent case, but of course that's plane travel.
But there is, when one looks generally at how travel services are defined, the formulation generally is travel services are in particular transport and or accommodation. And to give you the references to that, you've got Minerva, paragraphs 18 and 22, Star Coaches at paragraph 19, and Commission in Spain at paragraph 58.
So am I right in thinking that on your submission, rental of a bicycle is a transport service and therefore a travel service?
So, my lord, this is where the Upper Tribunal said one can have an argument about particular types of passenger transport.
But why? Because on your submission, they're all transport.
No, I'm not saying that. I'm saying that passenger transport by vehicle, by a car. And that is my case, passenger vehicle transport. And that is absolutely something that you
Sorry,
find.
what excludes a bicycle? Gets you from A to B?
Because there is, that doesn't fall within the general definition of passenger transport. That's not what under the UK legislation or under the EU legislation one sees as being defined as passenger transport. Whereas car hire and private transfers by vehicle one sees.
Car hire,
One sees car hire in being a form of transport, yes.
But if car hire is a form of transport, why is not bicycle hire? What's the distinction?
A bicycle is a bit like a horse, isn't it? And neither is various types of transport. A bicycle isn't generally encompassed within the concept of passenger transport.
Do the cases draw that, if I could put it this way, non-distinction? What I mean by that is just looking at Alpen, they've got the page open in Alpen Chalet, and the and/or paragraph 28 doesn't say passenger transport, it says travel.
Yes.
So it's not drawing a distinction between different kinds of travel that you are now drawing.
No, but I'm not saying that any type of transport, no matter how expansive, including taking a prisoner from a prison to court in a specially equipped van, is something that falls within TOMS. I'm not saying that, and I don't need to go that far. And this is why I do also rely, to the extent we need to, and this is accepted.
Sorry, can I just go back to on one thing? I mean, as I understand it, you're not saying that you have to have a passenger, that is to say someone other than the person who is controlling the means of transportation. And I put it that generally for obvious reasons. And that's why car hire, you say, is covered, because it could be just the driver. There's no requirement, as I understand you, for there to be a passenger.
Just to be clear on that, there are definitions of passenger transport, particularly in the domestic sphere, and I've taken you to the notice that HMRC referred to.
But I'm sorry, my question is about the EU case law and your position on the EU case law. And I'm trying to, you say car hire is included, but bicycle rental is not. And I'm trying to understand what the basis is, because it's not on the basis of, well, you don't have a passenger on a bicycle, whereas you can have a passenger in the car, because there might just be a driver in the car. So is it that it's got an internal combustion engine or electric equivalent? What's the distinction?
So let me clarify. I would adopt the definition which is used by the UK in passenger transport, and which one sees in the passenger transport notice,
Sorry, that's what the FTT did, didn't they? As well. You said yesterday you weren't going as far as the FTT.
I wasn't going to what, sorry?
Going as far as the FTT.
Yes, so I'm just addressing my law's question about what I say passenger transport is. Yeah.
Okay, but that, just to clarify, that's the phrase that the FTT used, isn't it?
I'm sorry, I'm completely baffled because my question is not about the definition of passenger transport. I can well understand that if one's inquiring about passenger transport, that it's kind of implicit in that you have passengers.
Yes.
And therefore you exclude any form of transportation where there are no passengers. That doesn't seem to me to be difficult. But that's not my question. My question is about what is the meaning of travel when we look at the EU case law. And as I understand it, you say travel includes a single service of transportation, and the single service of transportation includes car hire, but not bicycle rental. And what I'm trying now to understand is, well, what's the basis? It can't be no passengers, so what is the basis?
Well, my lord, I'm going to answer that in two ways. First of all, I don't need to go that far, of course, because I can rely on transport, meaning passenger transport. And secondly, I'd rely on the fact that generally transport has been understood as including a vehicle of some sort, and vehicle is generally not understood in this context to include a bicycle, any more than a sledge. So we were at 32 of the judgment now for chalets. And we go on to see that what the court then does is they say 33, since the mere supply of holiday accommodation by the travel agent is sufficient for special scheme, the importance of other supplies, which may be combined with it, cannot have a bearing on the legal classification of the situation at issue. That is to say that the situation is covered by the special scheme for travel agents. And therefore they don't need to look into principal ancillary 34. And then 35, the mere supply by a travel agent of holiday accommodation rented from other taxable persons, or such supply of a holiday residence combined with the supply of ancillary services, each amount to a single service covered by the special scheme for travel agents. Now here you'll see it's treating Alpen Chalets as a travel agent. It must do. That's the answer it's giving to the court, the national court. It's not distinguishing Alpen Chalets and saying, but you only resupply accommodation, you don't provide anything else. It's not even saying it's providing something identical or comparable, it's calling it a travel agent. Now then, could we go to the C case at page 380?
Can we just go back to the question asked?
At the top of 355.
Well, yes, because the question asked is about whether additional services are required, isn't it?
Yes.
That is the question being answered.
Well, and not only that, if we look at paragraph 19, as usual, the court reformulates the question, and it reformulates the question as mere supply by a travel agent. So the court is starting from the premise that it understands Alpen Chalets to be a travel agent. That's the premise it starts from. It's not a conclusion that it reaches from other premises, is it?
No, so one has to ask, why is that? It's had the Advocate General opinion, which has started off by asking, is it even a travel agent? And we've seen the description. We're going to have to assume it's it's proceeding on a well-informed basis. We've seen the description of what Alpen Chalets does. It is resupplying accommodation, holiday accommodation. It's not described as a travel agent. It's not described as such in the question.
But nevertheless, that's the premise that the court proceeds from. I mean, one might ask for rhetorically, why on earth, what's the basis for that premise? But that is the premise.
But then one would say, but isn't that then important, that it shows that you don't need to be providing information and advice? There's no requirement in Alpen Chalets that it needs to be doing anything more than resupplying holiday accommodation. And if that's right, then why is not someone doing an identical service to that within the scheme? So could we then go to page 380, which is the case of C. Now this, if we pick this up at page 383, we can see the description of the company at issue, it's paragraph 9. C, a company governed by Polish law, which is a taxable person for that purpose, carries on an economic activity as a hotel services consolidator. In the context of that activity, it offers its customers, namely entities carrying on a commercial activity, so this is B2B again, the possibility of booking accommodation facilities in hotels and other establishments with a similar function located in Poland and abroad. And 10, you can see that it resupplies, it purchases in and then it resupplies. 11, depending on its customers' needs and expectations, the company also provides advice on the choice of accommodation and help with travel arrangements. However, the referring court observes that C usually provides only an accommodation service. The price at which C resells that accommodation service includes the cost of purchasing that service and C's margin in the form of a booking price intended to cover the transaction fee. So 2 points to note here. It provided advice on the choice of accommodation. It's a B2B service, and help with travel arrangements. There's no descent into detail about what on earth that means here, but in any event, it usually provides only accommodation. And in 12, the tax authority took the view that the resale was not covered by the concept of what they called a tourist service. That authority essentially took the view that in order for a service to be regarded as a tourist service, it must, as a complex service made up of a number of external and internal services, consist of more than one service. However, the services provided by C, which cover only accommodation, cannot constitute a tourist service. They do not involve such a complex service. So they then refer to the question, and then paragraph 18 is the question. Must it apply to a taxable person, not a travel agent, to a taxable person who is a hotel services consolidator and who purchases accommodation services and resells them in cases where those transactions are not accompanied by any other ancillary services? So we then can pick this up at 22, the top of page 385. Specifically under Article 306 of the VAT Directive, Member States are to apply the special VAT scheme to transactions carried out by travel agents who deal with customers in their own name and use supplies of goods or services bought in from third parties in the provision of travel facilities. 23. In the present case, it's apparent from the request for a preliminary ruling that C, as a hotel services consolidator, purchases accommodation services in its own name from other taxable persons and then resells them to its customers, namely entities carrying on a commercial activity. It follows from what it's just said, that a company such as C satisfies the substantive conditions laid down in Article 306 of the VAT Directive in order to be eligible, in principle, for the special tax scheme provided for in that article. Then it goes on to say, furthermore, it should be observed that in the context of activities, C carries on transactions that are identical or at least comparable to those of a travel agent or tour operator. Thus, the referring court observes that depending on its customers' needs and expectations, the company also occasionally provides advice on the choice of accommodation and help with travel arrangements. Supposing there it looks as though what this court seems to be saying here is that you resupply, and as long as you occasionally provide some sort of advice, the transactions are identical or at least comparable. But then it goes on to say in paragraph 25 how it is necessary to assess whether provision of accommodation services is covered by the special scheme in cases where it is not accompanied by ancillary services. So we've got a slightly difficult to understand sequence of 3 paragraphs. The first where it says the substantive conditions are in principle met. Furthermore, it seems to be carrying out transactions that are identical, at least comparable. It occasionally provides advice. But thirdly, however, we need to go on to decide is the provision of services covered by the scheme where you don't have those ancillary services. And then it refers to Alpen chalets. It goes on to note in paragraph 29 that even a single service could be cross-border and could cause practical difficulties. And in 30, the answer to the question referred is that Article 306 of the VAT Directive must be interpreted as meaning that the service provided by a taxable person, which consists in purchasing accommodation services from other taxable persons and reselling them, is covered by the special VAT scheme, even though those services are not accompanied by ancillary services, and we see that in bold below. So even though Alpen Chalets was treated as a travel agent, somewhat inexplicably, nevertheless here we see in C, insofar as necessary, the court going one step further and saying, if you're a taxable person and you buy and resell accommodation, that's within the scheme, even though it's not accompanied by ancillary services.
Isn't that simply because that was the question they were asked?
That is the question they're asked, but it's very important because they're not being described as a travel agent, they're being described as a taxable person. And here, the answer being given, which of course is of general importance in the community, it's not being confined to its own facts, is that a taxable person who buys and resells is within the scheme. The accommodation services.
That's not the question that was asked. That's my point. The question was the article being interpreted as being applicable to a taxable person who is a holiday services consolidator, etc., in cases where those transactions are not accompanied by any other ancillary services? And the answer to in cases where those transactions are not accompanied by any other services was no. It doesn't matter when I'm putting my nose and my yes is the wrong way around. You understand the point I'm making?
My lord, is the suggestion that as long as you provide advice on one transaction, then your other 99 are within the scheme, whether or not, but you need one transaction where you're providing advice? Is that the suggestion, that in order to have the status, because that's not what the answer being given is?
I'm not fencing with you, mister.
No, I'm just trying to answer your questions, my lord.
The point is that as I read paragraph 30, it doesn't grapple with the question of whether the provision of the accommodation services does or doesn't, is or isn't something identical or comparable to being a travel agent. What it's grappling with is whether the fact that these services are not accompanied by ancillary services means they're not in the scheme. That's what it's grappling with, and it answers that question.
Could I make a submission on that?
And that's the reason, and that's why I reacted, because your submission seemed to be reading something in 30 as grappling with the question of whether the services are identical or not with a travel agent. And I confess, a rather simple-minded way, looked at paragraph 30 and I couldn't see those words in paragraph 30 because they're not there.
But that's partly, my lord, because the legislation does not have set out in itself the requirement that transactions are identical or at least comparable.
But what it actually sets out in the directive is you must be a travel agent.
Yes, but then we've seen that that's been interpreted. And this is where, my lady, you've asked repeatedly, do we say there's any difference between the UK and the EU? I say no, because the UK makes it clear, and we say this entirely consonant with the EU legislation, with the EU case law, that it applies to any person who provides services of any kind commonly provided. Now, if this court is not with me on that and considers that the UK legislation is more generous, that's not a point that's ever been made, then of course we'd say we rely on the UK legislation. But we say the UK legislation correctly says it's not a formality, it's not a formal label, and there cannot be a distinction between C and the next economic operator, one of whom occasionally offers advice and the next one who doesn't. And I say that's what you do take from this, that this is answering, are the services provided by a taxable person, not a travel agent? It's not saying by a travel agent, it's by a taxable person. So this is what I'm saying, when one looks at the evolution of this scheme and the case law, this is in line with what the Advocate General was saying in Alpen Chalets, which is this notion of informational advice is a bit of a nonsense in modern day anyway, but it's not necessary. And so this is what brings me to my submission, which is that what is a travel agent? It's someone who is providing the services, the travel services of a kind, which one sees being offered by travel agents, accommodation and passenger transport. You don't need any other feature. Or if you do, it's information advice, and Bolt provides that, as was found by the FT2. And this is why I started my submissions yesterday with the oddity of this scheme, which is labelled as being for travel agents, but when you look at it, how is it being applied here? It's being applied to a B2B hotel room consolidator, where they're not providing any advice. They are not remotely comparable to what one would think is the paradigm of a travel agent. And that's VAT legislation for you. Now, the final case, the only case that we have on transport alone is Dragaram, which is the most recent case.
So I'm right in thinking we don't have an official translation.
We don't have, it's not published, it's only published in Romanian and French, but we do have the French version in here. Now, it doesn't advance matters very clearly because this was a travel agent. So it's not looking directly at someone who's not a travel agent. And in that case, the question put to the court was, one looks at the top of 393. Can the service that the travel agency provides by reselling airline tickets, but to which it adds a margin, be considered to be a single service provision, since it automatically intrinsically includes, in addition to the sale or resale of airline tickets, services that are specific to a travel agency, such as information and advice? That was the question that it was being put. So we'll see it's not really of assistance to what we're doing, which is removed from that. Because in that case, Dragaram wanted to benefit from the reduced rate for for plane transport. But it had to be within TOMS if this was a single service within TOMS. Now, the court sets out the case law. And then we can see it go through Alpen Chalets, everything that I've gone through, and then says in 33, it can therefore be clearly deducted.
Sorry, just
yes.
before we get into the detail, can you help me on something I find mysterious about this judgment? I don't think it matters at all, but I'm just slightly mystified. If you look at paragraph 23, it says the court considers that the answer can be deduced from 3 judgments. And the second 2 are of course Alpen Chalet and what you call the C case. But the first one that's mentioned is Commission Germany, which doesn't seem to be referred to elsewhere in the reasoning, unless
No, my lord, I hadn't
escaped
spotted
my
that.
attention.
You're quite right, I hadn't spotted that.
So it's correct that that's not referred to elsewhere.
No, sorry, it is.
So it comes in at 37.
It comes in, yes, at the next question.
Oh, I see. That's the explanation. It comes in when they're dealing with the first question at 37. Okay, thanks.
So paragraph 33, it can therefore be clearly deduced from this case law that the sole supply of passenger transport services bought from taxable third parties by travel agents for its customers falls within the scope of the special VAT scheme for travel agents, regardless of the fact that this supply is not accompanied by additional services, or that the agency also provides information and advice service to its customers. You can see it's talking here not just about planes, it's talking about the sole supply of passenger transport. And it's got this rather odd clause at the end. Now we have the French translation at 403, if you want to have a look at that.
You mean the French original?
Sorry, the French original, yes. And one can see in paragraph 33, that last clause, interpreted literally, would be independently of the circumstance that the sale is not accompanied by supplementary services, or that the agency provides also services of information and advice to its clientele. Now, what it's not saying is it falls within the scheme because it provides advice and information. It's regardless of that fact. And that's the most assistance that this case law provides. That's where the trail ends. And one has the job of applying those principles and trying to make a coherent sense of Tom's and where it now stands in light of all of that. And I'm going to make a few points from that case law. The first is that in none of these CJU cases do you find an evidential inquiry into what travel agents or tour operators frequently offer. And that would, of course, require one to look not just at one member state, but across Europe. One would have to think about the point in time. This is a constantly evolving industry. And of course, it's not about frequency, because you heard my point yesterday, that otherwise one would exclude the innovative or the niche or the atypical, something like a private jet. So the first point is no evidential inquiry into what travel agents or travel tour operators frequently offer. The second point is we've seen the closest we get to the definition of a travel agent is offering multiple travel services. The third point is that travel is not defined, and travel services are referred to as including, in particular, transport and or accommodation. I've already given you the paragraph references for that, but that's just so you have it here. Minerva, paragraphs 18 and 22. Star Coaches, paragraph 19. And Commission in Spain, paragraph 58.
Sorry, can you just repeat those? Minerva.
Sorry, Minerva, paragraphs 18 and 22.
Yeah.
Star Coaches, paragraph 19.
Oh, got it, yes.
And Commission in Spain, paragraph 58.
58.
58. The fourth point is that to fall within the scheme, the services do not need to be provided as a combination. It can be a single service. And the fifth point is that travel agents may provide advice and information, but that is not a necessary part of the supply for it to fall within Tom's. And for that, I really rely on three cases: Van Ginkel, Alpen Chalets, and C. And secondly, there is no requirement as to particular nature or form of that information and advice. And the sixth point is that what one can see from the cases dealing with traders who are not traditional tour operators or travel agents, in that they do not offer multiple services, or they offer something different, is that services which are identical or comparable to a travel agent are bought in and resupply services of passenger transport or accommodation. And it's at that level of generality because one would not say that a 9-month stay in a foreign educational establishment is remotely comparable if one's looking at a typical offer from a traditional tour agent. Now I'm going to address head on the argument that's put against me is that you've removed travel agent from the scheme. It's now reduced to resupply of passenger transport and accommodation. And I say, yes, that is the effect of the case law, and the rationale for it is explained by Advocate General Bobot, I say. That provides a rationale. It's not one that's explicitly adopted by the court. I of course accept that. But it explains why we've reached that place in the case law. And it comes back to the point, really, what is a travel agent? There is no paradigm, there's no definition. It's someone who offers multiple travel services. So I'm going back in a circle here, but this is why, when one grapples with this is why the starting point of is this something you'd find in the UK market frequently offered is not the right answer, it's not the right question. So we say, that's our primary case. The alternative is that this fig leaf of a travel agent is kept by the suggestion that they must at least occasionally provide advice or information. And if one accepts that fig leaf, then we say we meet that condition. And we say passenger transport obviously includes transport by plane, transport by coach, transport by train. We say transport by private vehicle. There's no basis to say that's not part of the EU travel industry. Of course it is. And we can see there's a spectrum of transfers. On one end, you could have a private transfer by car, which is an alternative to a flight or train or coach to the local transfer. Just as you have a spectrum of accommodation from a paradigm to a 9-month stay in an educational college. And we also say that approach accords with the wording of the UK legislation, which we say is a faithful implementation, which is the travel service of a kind. You're looking at the category, the class. You're not delving into an evidential inquiry as to whether that particular subclass or particular factual iteration is frequently on the market. And that provides simplicity and workability. And we say it's entirely consistent with how TOMS has been operating for years. I've already shown you in the passenger transport notice 744A, which says at a broad level, you resupply passenger transport, you're within TOMS.
Sorry, which notice are you referring to?
That was 2 that I took you to, the one behind tab 2 at page 49.
Again, you seem to have slipped from transport to passenger transport. But on your case, this is not restricted to passenger transport.
On my case, I am saying it's passenger transport. That's what I rely on.
Where does it come? Where does passenger transport come in your analysis of the case law? Because I thought you told us the travel was. This was your third proposition. Travel, you say, is not defined. Travel services, and maybe I misnoted your submission. I thought you said travel services include, in particular, transport or accommodation.
Yes, that's why I'm using the wording of the CJU. But they also do...
So where does passenger transport?
Drag around, they refer to passenger transport. Drag around.
Yes, well, of course, transport includes the subset of passenger transport.
Yes. I don't need to go further than that, my lord. I don't need to have an argument today, or I don't need to argue the case that car hire is in. I don't need to do that. I say, I need to show that passenger transport by private hire vehicle is in.
To be sure, yes.
Yes. And I say it is.
But I thought you were giving us your submissions as to what the case law established. And I'm still struggling with where passenger transport comes in on your analysis of the case law. I appreciate, of course, the question for us at the end of the day is why there's all about passenger transport. We're not concerned, as you rightly say, with whether other forms of transport, like freight, would be covered as well. But I'm still asking for your assistance as to where, in your helpful analysis of the case law, you say passenger transport comes in.
I'm saying, using the verbatim language of the European Court, it refers to travel services, including in particular transport and accommodation, and that we know that passenger transport is a subset of that, and we see it referred to in Dragoram. And so I don't need to go further than that. There might well be a very interesting argument as to whether you're not a passenger. That could be within TOMS. I haven't investigated that in the case law because that's not anything that I need to do.
Thank you.
Now we'll see that that also accords, and of course accept, the limited use that the limited reliance I can place on the VAT guidance. Can I just emphasise that what I'm doing is showing that what the tribunal said below, is not radical or unworkable. On the contrary, what they have done is entirely consistent with HMRC's own statement of how this works in practice. Now I've already taken you to tab 2 at 744A, which says if you resupply passenger transport, you are within TOMS. And behind tab 1, we have a clear version of the tour operator's margin scheme notice, which was in the bundle but was cut off at the bottom. And one can see in 2.1, TOMS is a special scheme for businesses on page 4 that buy in and resale travel, accommodation, and certain other services as a principal or undisclosed agent. Who it applies to in 2.2 covers anyone who's making the type of supplies detailed in paragraph 2.1, even if it's not your main business activity or you do not view yourself as a traditional tour operator. And 2.9 on page 6, the following are always margin scheme supplies: accommodation, passenger transport, hire of a means of transport. So, my lord, there's a distinction for you between car hire and passenger transport.
The third bullet point would seem to cover bicycles.
Well, maybe Ms. Metropolis could answer that as to what HMRC's policy on bicycles is. But we can see what we don't have here is any additional criteria that one needs to carry out some sort of evidential inquiry as to particular details of the factual iteration of the supply being made. Now, HMRC say here bulk supplies are not comparable. They're not of a kind because they descend into the detail of the routes. They rely in particular on the routes and destinations. We've had a lot of getting a cab to my friend Bob's house, or scheduling. You can be standing on the street and get it immediately, and indeed at the time in 2022 you couldn't schedule. Now, if we're descending into that level of detail, then you are differentiating on the basis of routes or distance or scheduling. And that raises a number of problems, which one does not find in the Tom's notice at the moment, which is what are the relevant comparable factors? How does one establish which routes are comparable and which aren't? We can all agree that cab to Bob's house is not typical. If one's looking at frequency. But what about the cab journey or the private hire vehicle? One could call it a chauffeur, it's the same, it's just a label, to Edinburgh instead of a train or a plane. If one's differentiating on routes. And how is the tribunal below supposed to establish this comparability? Who is the paradigm travel agent that this is being established compared to? Is it the UK or the EU? One needs to be shown. We had evidence, we see this referred to in the Upper Tribunal, we refer to it specifically, of standalone chauffeur services, as well as airport transfers. What's the tribunal supposed to do with that? Are they supposed to say, well, I don't want one, I don't want two, I need 10, or I need both the UK and the EU? It's exactly what the FTT said. What are they supposed to do with this evidence? What's the nature of the evidential inquiry? And this is really important because there are several cases standing behind this one. The tribunal needs to understand, if you're descending into the details, what is the nature of the evidential inquiry? What are the relevant factors? Because this case, as you have seen from the FTT, was looking at the case at the moment in time of 2022, but since then, after that, you did get scheduled rides. So that's the point of distinction. If that matters, if that's a factor, it doesn't apply to later cases. Tribunals need to know that. If it's routes, there are specialist airport taxi transfer companies. So are they in or are they out? My lady, you asked me yesterday about whether we had a fallback case on differentiation. I went back to the FTT and I had an exchange with Judge Sinfield. Could we go to the supplementary bundle at page 250?
250.
And the exchange runs on the right-hand side of the column, page 362 down to page 363. And if it starts with me saying, Miss Sloan, it's not a compare and contrast. Can you see that? On the right-hand column, top of page 362.
Yeah.
Could I just ask you to read from there down to the bottom of that page? It's all in the right-hand column.
Can you just help me understand what the relevance of this is?
My lady asked me yesterday, do we have an argument that if one looks into the routes, that there are routes which are comparable to a travel agent, a traditional travel agent, commonly provided, such as airport transfers?
All right, but I may be missing the point here, but that sounds like a point for a respondent's notice on HMRC's appeal to the UT, and then again on the HMRC's appeal to this court. And maybe I've missed it, but I don't think I've seen any such respondent's notice.
No, we don't say that. We say that because HMRCs, if you see how this has been dealt with by HMRC, they deal with it at, if we go to the core bundle, paragraph 30 of their skeleton argument. Which is at page 63. So HMRC are absolutely engaging with this. So this is the airport minicab rides. So their response is 30A.
No, I think we're at cross purposes. there's undoubtedly an argument which is clearly part of the appeal as to the relevance of the fact that 2.3% of your rights, or whatever the correct percentage is to and from airports. And as you rightly point out, that is squarely confronted by HMRC. But the relevance of that is to the question as to whether the totality of your services for your supplies, forgive me, fall within the scheme. Whereas I thought the point you were addressing us on at the moment is a different question, which is, suppose you lose on the supplies as a totality, do you have a fallback position to say that 3.3% nevertheless fall within the scheme? And that would seem to be a respondent's notice point.
So the way that we put it in the respondent's notice, which is in the core bundle at page 25, is we say that if the court adopted the wrong view, including in relation to the evidence, one can see this at the bottom of page 35, insofar as the court appeals contrary to the FTT that evidence in addition to judicial notice is required to determine the issues, and or that a detailed approach to the evidence is required, because the FTT didn't consider that necessary, we do rely on evidence and contend that in a correct approach to considering the evidence, that evidence is sufficient to establish its case.
Right.
But that's still supporting the overall decision that all the supplies are within TOMS.
Yes, but we would...
Forgive, please, I may be wrong, so by all means point me to the paragraph, but I don't think I've seen a paragraph that says, if contrary to our primary case, all of our supplies are not within TOMS, nevertheless, the 2.3% that are airport rides are within TOMS.
No, because we don't just confine it to airport rides. I mean, if the tribunal...
say this argument, you're running this argument on the totality of the supplies, and that I get. But what I'm trying to understand is whether we also have to consider a scenario where you lose on the totality argument. Do we then have to consider whether you can still succeed on the 2.3%? Which, as I say, at the moment seems to me to be a respondent's notice point, and I'm not seeing it in the respondent's notice, but I stand to be corrected.
So, my lord, we do not put it in that way in the response notice. What I would say is, if HMRC's argument is relying on routes, then we have always made clear that that is not a complete answer to our claim, and that could only apply, if they're saying you differentiate on the basis of routes, that rejection could only apply to where that whatever the tribunal decided or this court decided were the relevant routes. And that's why they have addressed this in their respondent's notice, and they say their answer to that is no, because you just exclude the minicab sector. That's in paragraph 30. So I dispute that we would have to put in a respondent's notice. We've put in our claim as to whether these fall within TOMS. If they succeed on establishing it only to the extent that certain routes are not comparable, then that decision has to be applied to that extent. And the other point is, I'm afraid there's no way of avoiding this because, as I said, there are lots of cases behind this, including bolts for subsequent periods, where the tribunals will need to understand what the implications of this are.
I think if you're going to say anything on your second ground, Ms. Sloan, you better do so.
Yes, what time would you like me to finish? We're aiming
Well,
to...
now, actually, but I mean, you obviously aren't going to finish
Yeah,
now.
well,
and I'm
let's
not
say
going to
something
make
on
you
round
finish.
two, my lord.
But
So moving then on to ground two. The court has a fairly detailed skeleton argument on this. And actually, as I understood it, my learned friend was not going through in a lot of detail quite a few of the points that she made. So I'm very much in this court's hands as to what you would like me to focus on. At a high level, I mean, there's a cluster of criticisms. Could I make the first point? That HMRC repeatedly make the point that a customer can't go and obtain the services of the driver other than through Bolt. And we do not understand why that's a relevant test. If you look at Alpen Chalets rented houses from owners and then resupplied them to the public. There's no suggestion the public that was somehow transforming them, rendering them in-house, materially altering them, because they're the ones who controlled the supply or said what was available or not. So we don't understand that at all. There's simply nothing in the case law which says you have to be able to independently go and obtain it, either directly from the supplier or from a different third-party distributor. The second point is regulatory obligations, and they rely on the point about licences. This is dealt with in the skeleton argument. The point is that there are 3 licences here. There's the driver's licence, obtained by the driver. There's the vehicle licence, obtained by the owner of the vehicle, usually the driver. And then you have to have the operator's licence in order to take bookings. So it's not that Bolt is holding licences which cover its drivers or the vehicles. Those are from the bought-in supply. The suppliers of the bought-in supply are themselves heavily regulated in their own right and hold their own licences. It's that anyone who wants to take a booking in certain geographical locations has to have a licence. Now, how that could possibly transform a bought-in service to something else, I confess I don't understand. And we make the point that there are many situations where tour operators or travel agents are subject to regulatory obligations, including in relation to, for example, Atoll. And I've included, we mentioned in our skeleton argument, and it's in this additional bundle, the regulations which impose Atoll licensing requirements.
That's statutory, is it?
Now, in the skeleton argument, HMRC relied on obligations imposed on the suppliers, for example, ensuring safety in the supply chain. We deal with that in our skeleton argument, showing, including by case law, Cosmos Holidays case and Thomas Cook case, it's very typical for travel agents or tour operators to have contractual arrangements with the people from whom they are buying in services to make sure that they are safe and meet certain minimum standards. Then the second cluster of criticisms relates to the platform. And this is dealt with again in the skeleton, and there was a lot of evidence on this, which we do rely on, including the respondent's notice, to this extent it wasn't referred to in the FTT in detail, which goes through each of the points about the platform and these other points, showing that these are very typical. I mean, the platform is just a modern means of people being able to book. In the same way that I could go on any number of apps to find a hotel close to the Rolls building, which has availability for 5 o'clock this afternoon. I wouldn't know where those were. I wouldn't know what had availability. I could readily go on the app and find it. And it can be last minute. It can be very helpful. So we say that there's no point of distinction there. Now, my final point, my lords, my lady, was addressing you on the proper course if the Court of Appeal considers that the tribunals are below. Would you like to hear me on that or not? Or is that something you'd rather have submissions on after the event? I mean, I'm very much in your hands. I'm conscious of the time.
I think we should hear it. Yes, please.
So, of course, it's difficult because I'm having to do this without any knowledge of what the error of law could be, so it's necessarily hypothetical. But we would say, if this tribunal decides the lower courts address this at the wrong level of generality, then it would be necessary to appraise the evidence in light of the correct level of comparability, because the tribunal did not do that. It was quite open about the fact that it did not consider it needed to undertake a forensic exercise. And so we'd say, as in so many cases where there's been a wrong approach to the evidence, it'd be right to remit it. There's
And remit to the FTT for the avoidance of doubt. And just help me, I mean, I appreciate that circumstances vary, but sometimes this court will remit back to the UT. Why would that not be appropriate in this case?
I can't imagine, can't immediately see a reason why that would be ruled out. I have to say I'm not familiar with a case where that's been done, given that the Upper Tribunal can...
I've certainly been on a constitution of this court where that has been done. I mean, it varies according to the circumstances, and I'm not sure there's any clear test that you can get from the authorities as to when you remit to the FTT and when you remit to the UT. It's inevitably a case-specific determination, I would have thought. But what factors would you put forward as assuming we remit at all, remitting to the FTT rather than the UT?
Well, there is a case management issue because Bolt has other periods. So the tribunal looked at this, as I said, frozen in time at 2022, because we mentioned that scheduled rights have been introduced after that. And the tribunal said, no, we're only going to look at 22. So we've got backed up behind this, later periods. We also know there are other people in the industry. So there might well be a case management issue which the FTT would want to determine as to how to manage the group of cases in order, if it's looking at more detailed evidence, to decide how effectively to manage that and have the right evidence in front of it for all the relevant periods. So I think that's quite a powerful reason.
Well, that seems to envisage that any remittal would involve further evidence. Why so?
Not necessarily, my lord, but what I'm saying is, if the tribunals were going to look at this and there were different evidence for different periods, it might make sense for that to be dealt with. So one could imagine this case being heard alongside at the same time. It'd obviously be more efficient if, let's say, the tribunal considered it relevant as to whether the rights are scheduled or not, or whether there's a specific carve-out for airport transfers, then rather than have this case heard by the UT and then a case for a subsequent period heard by the FTT, makes more sense for those to be heard together. In a way, I don't want to tie anyone's hands now, but that one can see that at least parties could make submissions on the correct approach, the efficient case management in those circumstances.
Fine, I think I understand that. Can I ask a different question? It's implicit in what you submitted already. You say that this court is not in a position, if it finds an error law, and I emphasise if, to form its own view.
Yes, I do say that.
And why do you say that?
Because one needs to go into the evidence. I'd want to make the submissions on the evidence. You've seen my respondent's notice saying that we would want to make submissions on the evidence on a variety of points, depending on what you found against me on. Could I also note, just that yes.
Just to understand that better, obviously submissions on the evidence were made in the FTT. Wasn't that your opportunity? Because you didn't know then what the FTT were going to say. Wasn't that your full opportunity? And the FTT's made the findings, or let's say the non-findings, that are particularly relied on by HMRC, and we've been taken to the paragraphs.
So
wouldn't this be a second bite at the cherry?
No, so there are two different issues here. But could I just maybe set out a procedural point, just so this court's aware of it? Can we go to the supplementary bundle, page 16? So to the Upper Tribunal, this is HMRC's grounds of appeal. They set out in paragraph 30, effectively, the tribunal had found in paragraph 105 they weren't comparable, end of the case. And they also said in paragraph 35, you can look at the end of paragraph 35, there's no evidence before the FTT to support any finding that tour operators, travel agents provide unpackaged PHV services on any of the routes covered by Bolt. So these were all points, there were points on the evidence raised in front of the Upper Tribunal, all put in a respondent's notice,
we were told that that had not been pursued. Is that incorrect?
That's incorrect. It was pursued. I don't understand that.
Right, okay.
If we go to paragraph page 31, we relied on grounds to uphold the decision for additional reasons. And we relied on evidence of traditional travel agents providing passenger transport by vehicle from point A to point B at short notice.
Or paragraph.
That's in paragraph 9, little Roman 1. And we also put in paragraph 12, in the alternative to our primary case, the FTT was correct, and only insofar as the Upper Tribunal accepts HMRC's contention as to the proper interpretation of the paragraphs below, which is disputed to Bolt by Bolt, Bolt contends the tribunal erred, because HMRC seemed to be saying that the tribunal had found very broadly that there was no comparability. And we say what it was saying was, we accept this, that travel agents don't do the home to Bolt style. Right.
Yeah, well, paragraph 13 is the clear challenge to the paragraphs relied on, so 92 and 105. So that's, and I understood Ms. Metropolis to accept that there had been a respondent's notice on that. You say that was pursued.
Well, then paragraph 14, but it says obviously only on the basis that the tribunal agreed that that's what happened. And then if we go to the Upper Tribunal, there was then, and I know my learned friend didn't want to get into this, and it is difficult to do it in short order. So if we just go to the core bundle, to the Upper Tribunal, if one goes to paragraph 78, that's page 118. You can see that the error, the stated error, was that, this is HMRC's case, Bolt provides rides to and from places that tour operators do not typically serve, and that Bolt service operates on demand and 24 hours a day.
Sorry, where are you reading?
Sorry, paragraph 78, bottom of page
Yes.
118. Okay, so the FTT ignored those. This then led into paragraph 80. Could I ask the tribunal to just read from 81 down to 85? 80 down to 85, sorry.
80 to 80.
80 down to 85, yes.
Is that addressing your respondent's notice, paragraph 13? It seems to be.
Yes.
A dispute about JR 28.
But we didn't need to pursue the cross appeal to the Upper Tribunal in those grounds, because the Upper Tribunal,
Well, I could quite understand it if the upshot of the Upper Tribunal's decision had been they didn't get to paragraph 13 of your respondent's notice because they dismissed all the grounds of appeal. And that would simply mean that the respondent's notice point had been undetermined by the UT, in which case presumably you would have revived it by respondent's notice to this court.
but we considered we didn't need to, because what we rely on here is the Upper Tribunal saying JR 28 is in, and what the tribunal was saying, they're not, the FTT was not rejecting evidence on crosstown transport standalone transfers, and that's the proper reading of the FTT's decision.
I'm sorry,
Okay.
I'm sure.
Oh, sorry.
I'm sure it's my fault. I'm not
No.
understanding. So let us assume for this purpose that contrary to what we were told, you did pursue respondent's notice paragraph 13. Now, I think at the moment, but again, I stand to be corrected, that there's no decision by the UT on that
To be,
paragraph.
no, to become clear, I did not, no, it's absolutely right. I did not specifically ask the Upper Tribunal for a decision on that, because you'll have seen the way that we put in the response notice is we raised it only if the Upper Tribunal wasn't with us on the correct interpretation of the FTT and what the FTT had said. And there was a sideshow about whether JR28 had been excluded or not. We say it wasn't. HMRC have always said that JR28 was excluded.
That's a different question, because at the moment I'm just concerned about Respondent's Notice paragraph 13. So you didn't ask for a decision on that, you didn't get a decision,
No.
and there's no Respondent's Notice in this court.
There is a Respondent's Notice,
But it doesn't
say that, no.
So it is the bottom. What I'm concerned with is we haven't got an equivalent of paragraph 13 in this.
We
court.
don't, but we say, and this is really important, we don't challenge a finding by the FTT that there was no evidence that traditional travel agents or tour operators provide services on the route of, say, home to the pub.
Sorry, you don't challenge what is said in those paragraphs.
No, we don't, that's not. So if we go, let's have a look at paragraph, we go to the
So sorry to interrupt, but just as I'm clear, because
Yeah.
these points disappear from what was mine, so therefore I'm used to getting about. Your position is, if I've understood you correctly, that in this court you're not challenging FTT paragraphs 92 and 105, but you say that's not the end of the story.
That's absolutely right. And what we say, my lord, absolutely right. What we say is, because what it says is in paragraph 105, could we go there? Because this is important, 166. If we got at the top of page 166, while some of the evidence suggests that tour operators and travel agents supplied point-to-point transport, e.g. airport pickups and transfers, I was not satisfied they commonly provided on-demand rides from point A to point B, which were the same as or similar to those provided by Bolt. Now, what does the tribunal mean by that? Well, we can see that in paragraph 109 and 110, where it says, I do not consider the fact that Bolt provides rides to and from places, e.g. a supermarket, restaurant or cinema, which travel agents do not typically serve, as making a difference in principle. And then in 110, he talks about the on-demand. So that's why we say, we don't challenge, we accept that if it's at that level of distinction, one's looking at the routes and the destinations, and one has to have evidence that a traditional tour operator does that, then we did not have evidence that traditional tour operators frequently take you from home to Bob's house. We don't say it goes further than that, and we say that's not the end of the story, and you've got this, I'm sure, because that's like saying, is there evidence on traditional tour operators providing a 9-month stay in an educational college? No, you're never going to have that evidence. But that's why we did rely in the Upper Tribunal, and the Upper Tribunal accepted, and that's why I took you to, that there was evidence on standalone transfers. That was an additional reason, to the extent that it's not clear, but the Upper Tribunal said, well, we think that is clear, and it was also shown by JR28.
And then on the subject of JR28, just a quick question. The point was made, well, we can't see the terms and conditions, so you don't know whether it's principal or agent save in the case of one.
Yes, now we say, we don't understand that being necessarily relevant, because remember, to be in TOMS, you can be a principal or an undisclosed agent. So you can be an agent. You can be, in TOMS. If we go to the TOMS notice, you've got to be acting in your own name, but you can be, if we go to 2.1 on page 4 of the additional bundle, if one looks at the notice,
And how is that within Article 306?
acting in your own name. 306 talks about acting in your own name.
And you say that includes, as a matter of European law, acting as an undisclosed agent?
That's what it says here. That is acting in your own name. Can you see that at 2.1?
No, you're talking about a non-statutory notice issued by HMRC. My question is a different one, which is, as I understand it, your submission is that when Article 306 of the PVD says in your own name, that is not restricted as a matter of European law to acting as principal, but extends to acting as an undisclosed agent. And is there any support for that submission in the case law, is my question.
That's never been an issue below. It's not something that what we did was we put in a witness statement setting out the evidence on the transfers in JR 28. That was not objected to. HMRC had an opportunity to put in their own witness evidence. They didn't. The witness was cross-examined, and to the extent that it suggested that we'd have to show that it was acting as principal, that's not something that HMRC have, we'd say, properly pursued below. Now, if actually the tribunal would need further evidence on that matter, then of course that is something they'd have to consider whether they'd want to hear further evidence on. My lords, my lady, is there anything else that I can address you on?
No, thank you very much, Ms. Sloan. First of all, Mr. Governors, don't worry. I don't think you're going to finish by 1 o'clock and don't feel you should. I mean, if you can, that's obviously great, but don't feel pressure to do that. We can hear you after lunch if we need to.
I'm grateful and I should be finished by 1. But obviously, if I take it too quickly, do slow me down.
Yes.
Inevitably, it'll be a series of points, not necessarily in a coherent order. Picking up the last point, the idea that we never said it mattered whether you're a principal is a surprise to me. The situation was that Bolt acted as an agent, or claimed to be acting as an agent. The non-statutory ruling came about because they wrote to us and said, we're now going to act as principal, we're going to use the TOMS. Do you agree? And we said no. So the last point was a new point to me. On JR 28, my learned friend is well aware that we thought if somebody is acting as an agent, or there's no evidence they're buying in and reselling, they're not a relevant comparator, because the reason we had a fight about JR 28 is because we went off and looked at the websites and put in any terms that said how these JR 28 traders were acting, and that's the further documentary evidence the tribunal was worried didn't come with a witness statement.
So you say
And
you made the point about principal or agent.
Yes, and I can't, of course, rely on the evidence that didn't come with a witness statement. And my learned friend can't assert that any of these traders were acting as principal when, in fact, the only one that mentions the term says Love Actually, or whatever it's called,
I mean, I
acts
haven't
as an
raised
agent.
this before, but I found the whole discussion of JR 28 quite jurisdictionally a bit difficult in the Upper Tribunal, because the Upper Tribunal's initial role is to determine whether there's been an error of law, and it only gets into a potential fact-finding role if it's A, found an error, and B, set the decision aside. So I know neither party's raised that, but it's not I don't find the position in relation to JR 28 jurisdictionally easy.
And that takes me to another point. I made the submission yesterday that my learned friend had the challenge of irrationality to paragraphs 92 and 105 in her respondent's notice, but made no submissions on it. If you could turn up page 88 of the core bundle, is my learned friend's skeleton in this court. Core bundle, page 88. Footnote 44. HMRC also erroneously state that Bolt rightly did not pursue at the hearing before the Upper Tribunal its cross-appeal or criticisms against FGT's conclusion at 92 and 105. The fact that the cross appeal was not discussed orally before the Upper Tribunal does not mean it was not pursued. So I was surprised to hear my learned friend suggest that I'd somehow got it wrong, that it wasn't pursued orally. In other words, there were no oral submissions.
That they didn't ask for a decision on paragraph 13, and hence there was no decision.
That's different from I didn't make any submissions suggesting 92 and 105 were irrational, which is what's being confessed to in footnote 44. So having not included a claim of irrationality in the skeleton argument and then not pursued it orally, we say it didn't challenge. It put it in the respondent's notice, but didn't pursue the challenge. And moreover, as the court itself noted, it certainly didn't challenge it in this court in its respondent's notice. So I'm afraid my learned friend is stuck with 92 and 105 in particular.
Well, she accepted she wasn't challenging those paragraphs in terms. Her submission is that's not sufficient for you to succeed.
Yes, and I do this partly under the, and I'm sorry to sort of take it backwards in a way, but it's the remittal question. If this court is with us and the test is as we describe it, our position is, why would you remit? You've got a finding from the FTT on our test at 105. Comparability wasn't established. My learned friend's submissions about the need for further evidence and so on is close to what happened in the Upper Tribunal. You heard my learned friend say, oh, but we need to know quantitative assessments and empirical evidence, and we need to work out how many travel agents supply what routes. And that's what the Upper Tribunal heard when it came up with its decision of HMRC's position is too difficult because it requires all this evidence. I hope I made clear, probably repeatedly yesterday, that our case does not require further evidence and quantitative assessments. It requires an appreciation of the key features of a minicab ride and an appreciation of the ordinary meaning of travel agent and tour operator. So go back to the FTT if I win on the test, for what? Nobody's suggesting, I'm certainly not suggesting that one has to have a sort of substitution, competition substitutability exercise be carried out and so on. In fact, the point was made against me below that, oh, but look, none of the CJEU cases discuss that sort of detail and they don't go into sort of competition exercises about, so it's not that sort of question. I accept that. The question is understanding the basic features of a minicab operator ride, i.e. private car, take me to any destination I want, door to door, 24/7 and on demand. We say the same holds if it wasn't on demand. Is that passenger transport service identical or comparable to travel agents and tour operators on the ordinary meaning of those terms? Answer, paragraph 105 of the FTT decision, having heard all the evidence and the cross-examination, and on my learned friend's case, having also looked at all the, how many bundles it was of documentary evidence on what Jet2 does or what TUI does or whatever else it was.
Just for what it's worth, Falk's position is that JR 28 was taken into account.
But even worse for my learned friend then, because having heard also JR 28, the court was able to say, the FTT was able to say, despite the fact that travel agents and tour operators offer airport rides, albeit typically packaged and so on, I was not satisfied. Sorry, I'm paraphrasing. I was not satisfied that their services were the same or similar, i.e. identical or comparable to travel agents and tour operators. So we say there's no need for remittal. Sorry.
Yes, just since we're on the question of JR 28, I mean, there seems to have been some confusion between two different questions, and I'd be obliged for your assistance with this. Question one is the exhibit in evidence? As to that, it seems to me to be quite clear that it is in evidence. There's no suggestion that it was ever not admitted or was excluded. Then there's question 2, which is a different question, which is, what does the exhibit establish? And there seems to have been, at least before the Upper Tribunal, some debate about question 1. But that's not the question. The question is question 2, isn't it?
I did, as I recollect, submit to the Upper Tribunal my words to the effect, my learned friend can't wave around corporate travel services, page 1 of JR 28, that one-page snippet, and assert this is a relevant comparator because agent, principal, buying and reselling, and on what way can we...
Your submission is, if I've got it correctly, is take the document at face value, it's not enough, because you need more. Have I got you correctly?
Yes. And even if one could unearth an entity that on its ordinary meaning was a principal and we would accept on its ordinary meaning as a travel agent, and it so happened to be also offering a minicab ride to my friend John's house, that wouldn't mean my learned friend gets home, as it were, because it's the ordinary meaning of travel agent and tour operator that matters. And if we found a trader that was otherwise a travel agent, but it had a side line of sending cabs from any A to any B I want to go to, we'd say, well, it's a travel agent, but partly acting as a minicab operator. Just as we say, sorry, there was another point. My learned friend said something like, well, what if you had a minicab operator that specialised in airport transfers, as in airport rides only? What would you do then? And my answer to that is, remember the Venn diagram and the 2 circles, and in the segment of possible overlap are the 2.3% of airport rides in this case. If we found a trader that had 100% of airport rides, he would also be in that overlap. And the question would be the same. I see you go to airports only, so your supplies are only to the airport, and we see that similarity with the travel agent sector. But we also see that you are a minicab operator that's private car, door-to-door, 24/7 on demand, or whatever it might be, or scheduled. And that makes you similar to the minicab industry more generally, and we'd have to make a decision about that, just as we'd have to make a decision about the 2.3%. It happens to be in Bolt's case. It's not about how many Bolt in particular. It's particularly worrying that anyone can extrapolate from 2.3% anything about 97%, but it's never to do with the particular trader. It's about the supply. An airport ride minicab supply is in the TOMS or it isn't. It doesn't matter what else that trader is offering. Is that clear, or have I confused matters by going into that example? A sceptical eye. One has to look at the nature of the supply and answer the test, which is this supply identical or comparable? That's the answer. One can't take one supply and say it follows, if one of your supplies is in, therefore another of your supplies is in. But it's particularly...
But the issue between the parties is, as Ms. Sloan made clear yesterday, is not whether that is a correct test. She didn't take issue with the proposition it has to be identical or comparable. The question is, at what level of generality do you undertake that comparison?
That's my elephant and ant answer. If one asks, is an ant like an elephant, the answer can't be yes, they're both animals. because what the provision is saying, are they identical or comparable travel agents or tour operators? So it's not asking for some umbrella category. That's the mistake the tribunal's made. My learned friend makes with respect, because in answer to the question, is it something identical or similar to travel agents? The answer is given, yes, because they both come under an umbrella category passenger transport. It's not asking that sort of question. Is an ant similar to an elephant? It's not asking for the answer, yes, they're both animals. It's asking, legislation, in other words, has picked out travel agent because it's similarities to that are needed. And that's why the high-level test raises the idea of travel agent, because it's treating the scheme as though travel agents were simply an example of a greater category. And before I forget, my learned friends seem to indicate there's something in the domestic provisions that allows this high level, is it of a kind? So this jumping up to the umbrella category. In Madgett and Baldwin, can I just show you quickly? It's Authorities Bundle, page 135. I just explain that you'll recall that section 53, subsection 3 of the Value Added Tax Act provides that extension of tour operator to include traders offering supplies of a kind commonly supplied by tour operators and travel agents, yes? So that of a kind idea. For once, the UK was ahead of the game because the UK had that in its legislation before the CJU ever looked at traders who weren't travel agents on the ordinary meaning of the term. And we see that at 135, the question sent to the CJU subpara 1. Question, what are the criteria for determining whether the operations of a taxable person are the operations of a travel agent or tour operator to which the provisions of the scheme apply? In particular, do the said provisions apply to the operations of a person who, though not a travel agent, provides for the benefit of travellers services of a kind commonly provided by travel agents and tour operators? So there can be no question that when the CJU gave the answer therein, if their supplies are identical or comparable, or at least at that stage it was just saying identical, that its answer covered the domestic provisions, as it were. It's not that my learned friend can fall back on the domestic provision. Taking into account the domestic provision, the CJU is saying identical transactions. And that's how that provision therefore has to be read. And apologies to take it out of order, but can I just note, sort of make the point as I go. On the Director Kratovich, the C case, that's the hotel rooms consolidator, my learned friend kept suggesting that this was a finding that a supply far removed from the travel agent world was found to be in the scheme. I don't understand it, and it's repeated by the Upper Tribunal at 71 as an example of something far removed. Director Kratovich and bedbank consolidators generally are buying hotel rooms, say 100 hotel rooms, selling them to 5 different travel agents who are selling them on to end users. So the nature of the supply, as in what you're getting, is the same room. It's a hotel room. Once Commission in Spain established that the traveller can include any customer, there's no difficulty there, because my complaint, of course, is not that Bolt doesn't have some formal travel agent hat on, as it were. It's that its supplies are not identical or comparable because of their nature. But the Director Kratovich's case, the supplies by their nature were paradigm instances of travel agent supplies. They were hotel rooms. Similarly with Alpenchalet, holiday accommodation. Not only, my lord has this point, not only does the CJAU formulate the question on the basis that Alpenchalet was a travel agent, but moreover, what's the nature of its supplies? Holiday accommodation. As for the claim that our approach stifles innovation, not quite sure I follow it, but to the extent my learned friend is saying, well, in a futuristic world, as innovation continues, we might one day get to a place where we have one type of trader and they supply all passenger transport.
Can I recast the argument in slightly different terms, which to my mind are slightly more legally relevant? I assume you wouldn't dispute that this legislation is to be interpreted as always speaking. That is to say that although it has its origins in Article 26 of the 6th Directive, which was quite some time ago, we interpret it in the light of contemporary conditions. I assume you wouldn't dispute that.
Is that, I have my answer, but I wanted to see if there was a further question linked to it. Let's start with that.
Let's start with
Let's start with that. In another case, I had reason to look at this and couldn't find an always speaking doctrine as such, but that doesn't matter because, yes, of course the always speaking doctrine, the form of it, will apply. But my learned friend sets up a straw man when she says that HMRC are arguing we're not traditional travel agents. We don't use the word traditional. We use the wording of the CJAU in the ordinary meaning of the term. And my answer to both the innovation complaint and to my Lord's question is the always speaking doctrine isn't engaged, because when I say the ordinary meaning of travel agent, I'm talking about the ordinary meaning today, or rather not engaged, but it's that nothing I say is against its application. Yes, so you use the ordinary meaning of travel agent today.
So it would include all the online and app type,
Fine.
.com or whatever it is.
We've never said those are out because we accept ordinary meaning, and also it's not. Our complaint has never been you use an app bolt. You didn't. The court didn't hear me say our problem is that it's app based. My problem is, and that's what, in answer to my lord, I made clear that if Bolt were a traditional minicab operator working with, as I was informed, radios in the car, I would be making the same argument against them. So I'm not complaining because Bolt is modern. I'm complaining because Bolt is not a travel agent, a tour operator, or making identical or similar supplies. Now, I think my learned friend's innovation point is perhaps a different one, and this is where you get in sort of slightly trickier territory, but we're not there. What if we imagine in a future world that the actual word tour operator has changed its meaning because now we only have one name, tour operator, for any trader that covers all passenger transport. And then you have an interesting debate about the always speaking doctrine and its interaction with EU law, which the Supreme Court had reason to consider in the News Corp case regarding the question of digital newspapers and so on. But we're not there. That's why I say I don't need to go into it. We're not there because on the ordinary meaning today, which I'm happy to adopt, including apps and platforms, they're not making supplies that are identical or comparable to travel agents, taking into account that travel agents also use apps and platforms. So does that answer my lord's question?
I think so, thank you.
And on that point, my learned friend said she made the concession that they're not a travel agent on the ordinary meaning of the term because they don't make multiple supplies of services. I'd never heard that before, but it doesn't matter because my key point is, even if my learned friend hadn't made the concession is inevitable. Because if I was standing outside the supermarket and my friend said, yes, I've just called the travel agent to send me a cab to get me home because my shopping's heavy, I'd suspect my friend's first language wasn't English, because the ordinary meaning of tour operator and travel agent does not include that service. On the Advocate General in Madgen and Baldwin referring to the taxi example as something ancillary, I think the court has my point, but just to respond to my learned friend's idea that there was some obvious inference there to be drawn. Imagine that the Advocate General says at the hearing the example was given. Imagine if at the hearing the example given was, I'm a hotelier, yes I provide coach tours around Devon, but that's no different from my after dinner entertainment I put on, a dancing show or whatever it might be. And therefore just ancillary to what I do. And the Advocate General said, in opinion, then said, well, yes, when they offer musical shows after dinner, that's ancillary, but the coach tour around Devon, that's far more substantive, it affects the package price, so we can't see it as ancillary. Would anyone really be claiming that the obvious inference is that, but for being ancillary, the musical entertainment is in the TOMS? No. And that's the point I make about hook to hang anything on. There's no obvious inference that the Advocate General meant, well, if it wasn't ancillary, then of course this is the kind of service that's in the scheme. In context, what he was trying to emphasise was the difference between ancillary and non-ancillary, and making the point that the distant coach travel and the excursion around Devon couldn't be seen as ancillary because they changed the package price significantly. I think I've answered the point about my learned friend hasn't and still doesn't challenge 105. 105 was on full evidence. If the court is with me on ground one, there's absolutely no basis for some second bite at the cherry. I don't ask for quantitative evidence. If my learned friend thinks that anything turns on quantitative evidence, then as my lady pointed out, the opportunity to bring forward such evidence was open to Bolt before the first tier tribunal. It said brought forward all the evidence it wanted. The FTT considered it, reached a conclusion on the evidence that Bolt doesn't challenge. It's hard to see why anyone would be going back to the first tier or the upper tribunal to decide what's left to decide, as it were. The only reason the FTT didn't follow its finding through is because it then, in the next sentence, in fact, said, but it doesn't matter because the high-level approach is the right one, whereby I ask, in order to answer the similarity question, I ask the umbrella question. Do they come as though travel agency is an example given in the scheme? So anyway, those are my submissions, and there's more questions on remittal. On the Dragaram case, this is the plane tickets, and I think it also, I hope, completes a question that was put to me by Lord Arnold yesterday. I'm sure we have to turn it up, but if you want to keep an eye on it, it's in tab 30, page 389. You'll recall that there are these lists of exemptions, zero rates, reduced rates. And there's also obviously the special scheme. And in certain cases, some countries were given the right to retain some exemptions on entry into the EU. And Romania was allowed to retain passenger transport exemptions on entry into the EU. And what Romania sought to do was A, implement the special scheme for travel agents, but then B, say, passenger transport can have the exemption unless it's more than one service. In other words, so for your note, the particular exemption is in para 7 of the decision. Para 12 sets out this implementation that Romania went for, whereby they implement the exemption, but say not if it's for more than 2 services, then you're stuck with the scheme. And then there's the discussion, which my Lord Arnold picked up on in paragraph 17 and 18 about, well, what if it's plane tickets and additional services? Because there was that struggle between whether it's to be put in the scheme or put into the exemption. But, and this is important, CJ, you made clear, the point I made at the outset, it's in the scheme even if it's one service, whether it's with advice or other services or not, it's in the scheme even if it's one service. And moreover, you, Romania, don't get to exercise the exemption over it once it's in the scheme.
So the national
Because you lose it.
The national legislation wasn't compliant.
It couldn't have the effect of, it couldn't have its intended effect of saying, well, if it's one service, we'll take the passenger, the passenger transport exemption. If it's 2, we'll take the scheme. The court was, and that's why you get these discussions of the advice and so on, because the court is saying, ultimately, even if it's just one, it's in the scheme. And moreover, just as we told you in Alpenchalet and in Cossack, once you enter the scheme, you lose, all other bets are off. So there's no option, and this is what happened with Germany as well, the German case that you'll see referred there, which is also in the bundle as the first case, but now we have drag around, we never needed to go to Germany. If you decide to implement the scheme takes precedence. It's not open to you to say, I'll implement the scheme and I'll implement an exemption and I get to decide if it's one service, it's exempt, but if it's 2 services, it's in the scheme. And it's paragraph 37 that says in the middle, precludes. So 37, in this respect, it's clear from Commission and Germany, ... the terms of which are set out in essence in 306 to 310. So the old special scheme and the new special scheme precludes that this member state can rely on an exemption not envisaged by that article. Therefore, the special VAT scheme provided in is a compulsory scheme for travel agents acting in their own name who supply tourist services using services provided by taxable third parties unless specifically specified in that directive. Because there is an exemption in the directive, you'll recall, for under 309 about supplies outside the, yes. But it's saying, forget the rest. You lose your reduced rate, you lose your exemption rate because it's, once it's in the scheme, it takes precedence. And that's all that was the reason to discuss this advice and information and so on. On advice and information, I may not have my learned friend's position as clearly as I'd like, but can I be clear at least on the position? We're not saying Bolt is out because it has its passenger transport, but it doesn't supply advice or information. We're saying it's out because the passenger transport it supplies is not identical or comparable to that made by travel agents and tour operators on the ordinary meaning of the term. So the advice and information point, it seems to us, an irrelevance. You lose because of the features I've identified, and because the FTT, considering those features, determined that you weren't identical or comparable, and you haven't challenged that. And the CJU's case law is indeed clear that you don't need advice and information in any case, so why would I ever be saying you're out because you don't have advice and information? I've never suggested we need multiple services, I've never suggested you need advice and information, but you do need a feature that makes your supplies identical or comparable, clearly. As in, you have to meet the test of are you identical or comparable, are your supplies identical or comparable to the supplies of travel agents and tour operators? And that takes us back to Magid and Baldwin and IST, and you have my submissions on those. Hotel rooms are obviously of the right nature. Holiday accommodation is obviously of the right nature. So the high point of my learned friend's
Yes.
case is the college accommodation.
Can we just pause on that? Because you would say, I take it, that not all of the accommodation is of that nature. So, you know, private rented sector doesn't work this way, but let's say there was a consolidator of private rented accommodation, then letting it out on short-term lets.
And of course, duration doesn't matter.
Possibly even student lets, picking up the IST case. I think that's also behind my question earlier about different kinds of transport. I think that's probably the one word, different kinds of travel.
Well, I say my answer is they have to be identical or comparable to the supplies of
Yes,
travel
but
agents, tour operators, and they're not necessarily
whether
all are.
accommodation was in a different category to transport, but
Same
in
test.
case it wouldn't be, would it?
I say it's the same test, whether it's easier to meet in case of accommodation because your need is to be, you know, in rooms near college, and that's more easily satisfied in a broader way. But if my need is to get to my friend John's house, a flight isn't going to get me there.
The contrary argument, if Sloan was standing up, would be to say that the CJEU has made it clear that there needs to be a journey, and therefore that would naturally cut out some kinds of accommodation.
Yes. I don't have more detailed submissions on accommodation than that, but I say the test is the same, and maybe one day I'll be back here arguing about accommodation. On the regulatory obligations to hold ATOL and APTA licences, I think those are for packaged provisions, but it doesn't matter the point I made on regulation. The key point I made on regulation is I can book a flight with an airline direct. It's not unlawful, a criminal offence for an airline to offer to sell me a ticket. My learned friend isn't claiming that I'm wrong on that. I'm not wrong on that, and therefore there is a difference. Sorry, I've moved into my ground 2 accidentally, which is a very short point, that to summarise in one sentence, my ground 2, in relation to minicab operators, the regulatory position is that bolt is needed, both in order to satisfy the requirements, but also, as I said, from a practical point of view, so that the driver and the customer can be brought together, and indeed the most proximate driver can be sent. I'm just checking very quickly that I didn't have anything else on ground 1, and we will be done by 1 unless there are questions. So I think I get extra brownie points for that. Again, one sentence on the notice 744A, and saying that if you're buying and selling passenger transport you have to use the TOMs. I go back to the one notice my learned friend doesn't mention. If one looks at that passenger notice that my friend refers you to at 4.7, which mentions taxis and hire cars, it sends you to the notice that I mentioned the first day in my clip, which is the taxis and PHVO notice from HMRC, which states expressly, if you're a business, open brackets, like Bolt, and you're using self-employed drivers, open brackets, like Bolt, then you must charge that on the full fare. So you're only being shown half the picture when my learned friend says, "I'll look at these notices that say resupplies of passenger transport must use the special scheme for travel agents." No, look more carefully. There's a clear notice for your own sector, Bolt, which says account on the full fare. But I don't, as I say, for reasons I explained yesterday regarding the JR, I don't want to get dragged into a parallel argument about the JR. I think my learned friend also said, well, if we do need additional information and services, we have it in the form of the free blog and the 24-hour helpline. So just to be clear, not only do I say you don't need those further services, but if there's a problem with the nature of your supply, as in your type of passenger transport is not in the scheme, adding a free blog on your website or a helpline, which is of course something any trader can have, is not going to bring you into the scheme. And there was no finding that that was the case, other than on the basis that if two are needed, Bolt has them from the FTT, nothing in the Upper Tribunal, because the Upper Tribunal recognised that nobody was arguing they needed to. I don't have anything further unless the court has any questions for me.
Thank you very, very much, Mr. Metropolis. I'm very grateful to you for your submissions. Unsurprisingly, I hope we will be reserving our decision. It will come out in the usual way in due course as an embargo decision. The embargo is important. I know you're aware of that. And I'm not going to give you any speculation about when it will be, but it will be as soon as we can manage it. And I'm very grateful to you and those behind you for all the work that's gone into this case. Thank you very much.
All rise in favour.